Hello and welcome to a new series of videos focusing on contract law in England and Wales. This video will serve as an introduction to contracts and the laws that manage them.
The objectives for this episode are to be able to define a contract, to understand the sources of contract law, to understand the importance of contract law, and to be able to identify the elements of a contract. Before we can look at how a contract works, we must first understand what a contract actually is. There is no formal definition of a contract found in the law of England and Wales. However, it is generally understood to be the law recognising that two or more parties have an agreement to trade. Trital, a recognised and leading authority, provides the following definition in his text, The Law of Contract. An agreement giving rise to obligations that are enforced by the law. Trital continues to note that the factor which distinguishes contractual from other legal obligations is that they are based on the agreement of contracting parties. When we imagine a contract, we might picture a complex document containing all sorts of legal terms, governing the way in which we might buy, sell, or even lease products or services. However, this is broadly not the case. Contracts do not have to be tangible or in writing to be legally enforceable in most cases. An important exception to this rule is a contract for the sale or other disposition of land or property. These must be in writing and contain all the terms agreed, otherwise they are not enforceable. Now we have given it a definition, we need to understand the sources of contract law. The primary source is common law, whereby judicial precedent and case law gives backbone to the law of contract. However, there are also statutory provisions which support contract law, such as the Unfair Contract Terms Act 1977 and the Sale of Goods Act 1979. Contract law lies at the very heart of our legal system. Freedom of exchange of goods and services in the marketplace is crucial in our society at every level. Contract law makes this possible. Without a system of obligation and penalty, bargains or trades would not happen. Contract law therefore serves to make an agreement enforceable. Basic examples of contracts are making a purchase of goods, a contract for employment, and procuring services. Most people are unaware that they have all entered into a legally binding contract at some point in their life. So, what do we need in order for an agreement to satisfy the conditions of being a contract? There are four elements of a contract: offer, acceptance, intention to create legal relations, and consideration. These elements will be discussed in further detail in forthcoming modules.
That concludes the first episode of this series. If you're interested in learning more about contract law, please feel free to subscribe to this channel and to leave a like on this video. Thank you for watching, and I will see you in the next video where we will be discussing offers.